has been glitching.
Your
I-
Honor,
Oh, it
Your
was
Honor,
a
he's
glitch when the
strict-
magistrate was saying.
But I am aware now, Your Honor, I am aware now that I'm not allowed to contact her whatsoever.
That's called the case of the people versus Stephen Johnston.
Good morning, Your Honor. Alex Green on behalf of Mr. Johnston. I'm requesting permission of practice pursuant to MCR 8.120 under the supervision of Attorney Lauren Brown.
Really? Okay, permission to practice is good.
Stephen Michael Johnston, Your Honor, how are you?
Thank you.
This morning?
I'm just wonderful. Yourself?
Sure, I could be doing better, Your Honor.
Yeah, I know. Sometimes it'd be that way. Go ahead.
Your Honor, we're asking the court to set the matter for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have the witnesses available on the 16th. Preliminary examination will be set April 16th in person, 9 a.m. before Judge Fresh Hour.
Also would like to be heard on bond. Good time.
Yes, go ahead.
2.1 is the amount of his bond and 2 are his phone calls. First, at the time that I charged this case, I requested a 50,000 cash surety bond. The magistrate set his bond in the amount of 40,000, 10%. I'm requesting,
40,000?
40,000, 10%. I
Okay,
don't know, yeah. But I'm requesting the 50,000 again. The defendant is charged with strangulation and domestic violence. There may be an additional charge of possession of meth coming as well. The suspected meth that the defendant had in his backpack upon arrest is currently at the lab. If we get those test results that come back meth, we'll be charging that also. But in this case, the defendant used one hand, put his hand around the victim's neck and strangled her. He then put his other hand into her face, covering her mouth and her nose. The lethality report that the police filled out reflected the victim was struggling to breathe while he was doing this. Prior to strangling her, he had hit her in the face with a plastic fan. And the police were able to observe injuries to her. She had redness to her neck and she then received medical treatment. The defendant also has 5 holds. 2 are from Trenton, 1 is from Lincoln Park, and 1 is from Dearborn. Those 4 are all traffic offenses. However, he does have a Dearborn Heights domestic violence hold with a $500 bond on that. I don't know the circumstances of that domestic violence case, but I'll be reaching out to them to get a copy of that report. So first, I'm requesting that the bond be increased to 50,000. Yesterday, I received notice from an intern that works in our office who had the opportunity to review all of Mr. Johnson's jail calls. And the intern sent me a memo about 8 of the defendant's jail calls. I immediately reached out to Mr. Warren Green. I downloaded the 8 jail calls and sent them to Mr. Warren Green. And I had the the Sheriff's Office Record Department yesterday send Mr. Warren Green all of the defendant's jail calls. So they've had access to them for almost as long as I have. In the 8 jail calls, the defendant placing calls to the victim despite a no contact order with the victim, they are discussing this case in detail. They've discussed the victim changing the story. The victim is going to take responsibility, that she's going to say that she remembers things differently. The defendant directs her to call the prosecutor's office and, I quote, be on their ass a little bit, make them drop the charges, tell them that you want this dropped. As if Ms. Barroso was here, she would say that he then engages in love bombing, telling her how much he loves her, that he wants to marry her, that he wants to put a ring on her finger, that he just wants to get out of jail, tell the prosecutors to drop the charges. My office has been in contact with the victim to continue to offer her support. The officer in charge from Ann Arbor yesterday was also in contact with her to offer her support as well to allow us to move forward with these charges. My office is into whether or not we will be filing a forfeiture for wrongdoing against this defendant should this victim ultimately decide to tell us a different story. However, based on the supports we're providing her, I'm hoping that is not the case. And we're also looking into witness intimidation against the defendant. So A, please increase this bond to 50,000 as I initially requested, and B, revoke his jail call privileges as well. Thank you.
Response.
Thank you, Your Honor. As Ms. Hughes said, she did send those phone calls over to me yesterday. I had an opportunity to listen to those. I had an opportunity to speak to my client. Mr. Johnston understands that any contact with a complaining witness is a violation of his no contact order. He assures me he will not contact her whatsoever moving forward. Our only request is that the court retain the 10% privilege in his bond. If Mr. Johnston were to post, he would reside with his grandmother in Redford. He was employed fully before this as a sales rep at AT&T. Mr. Johnson has 2 children and only has 1 prior conviction on his record for a traffic.
Just to, and maybe I didn't understand what you said. He has a 2023 domestic violence conviction.
Your Honor,
And Your Honor, I apologize. If that's true, all I can see in his Michigan criminal history is 1 prior conviction for the traffic matter.
Your Honor, may I speak, please?
We have an attorney. If you want to, you can go ahead.
Your Honor, I was not aware that I wasn't allowed to contact my fiance.
Really?
No, I didn't. When the video during the court in the inside of the jail cell has been glitching.
And Your Honor,
Oh, it
Your
was
Honor,
a
he's
glitch when the
certainly-
magistrate was saying.
But I am aware now, Your Honor, I am aware now that I'm not allowed to contact her whatsoever. But I did not love bomb my fiance whatsoever. My fiance openly in the
Stop
state.
it. Stop it. Your Honor, I think what Mr. Johnson meant to say is there were no
Oh,
threats.
what he meant to say, what?
He was absolutely not threatening any witnesses in the case.
No, I wasn't. Not
Was he
whatsoever.
telling her to change her story?
No, I was not. She openly, you can listen to the
Oh,
call.
you don't want me to do that.
No, but I'm telling you, the very first phone call with her, openly admitted to it. I didn't coerce her.
Your Honor, we're asking to proceed to preliminary exam.
Yes, miss. There's more?
No,
Go ahead.
No, just to be completely candid with the court, I said it was a conviction. I'm sorry. In 2020, he was bound over in Wayne County on the domestic violence and child abuse charges. I said it was a conviction. It just says bound over in the judicial segment. I apologize. So I need to be clear. I don't know what the ultimate outcome of that case was.
Your Honor, my understanding is that case is set for trial in May.
So he was out on bond in felony child abuse charges. And
When this occurred.
yes, thank you.
Anything else?
Nothing from the defense, Your Honor.
I would find that I'm not sure where the 40 comes from, but whatever. I find that the 10% is an abuse of discretion, given all of the circumstances. The defendant's the 10% privilege. I will not raise it to 50, but it'd be $40,000 cash surety. Will be his bond. Further, it was clear, and it was less than 10 days, well, less than a week. This defendant was arraigned, and all of this has occurred, and the phone calls have been listened to, and he shouldn't have been in any contact whatsoever with her. Just plain and simply shouldn't have been in any contact, regardless of the contact. Defendant's phone privileges are hereby revoked in their entirety. Thank you.
Thank you, Your Honor.
Thank you.
Does call the case of the people versus Edward Dominguez.
Se llama el caso El Pueblo contra Edward Dominguez.
Did you hear that, Madam Interpreter?
No, sir, we are
I didn't
having
think
some
so.
sort of audio issue.
It's okay. It's Nicole Hughes on behalf of the people.
A nombre del pueblo, Nicole Hughes.
Torshell Feaster, Assistant Public Defender on behalf of Mr. Dominguez.
Sir, would you mind repeating your name?
Feaster, Torshell Feaster.
Corshell Fister, nombre el acusado.
Assistant Public Defender on behalf of Mr. Dominguez.
Auxiliar, asistente, a nombre de el señor Domínguez.
Mr. Dominguez, please state your name for the record.
Señor Domínguez, por favor, diga su nombre para el acta.
Edgar Dominguez.
Thank you, Judge. I've had a chance to speak to Mr. Dominguez and to the people in this matter. I
Gracias,
previously,
Oh, sorry, sir. Go ahead.
Go ahead, Madam Interpreter.
Tuve la oportunidad de hablar con el señor Domínguez.
I previously believed Mr. Dominguez was out on bond, but the paperwork indicated he was in jail, so we did not connect, Your Honor.
You did not, what? I'm so sorry. The
Did
connection is
not
really bad.
connect. They did not get a chance to meet.
Thank you. Tengo entendido que el señor Domínguez salió bajo fianza, pero en los papeles decía que estuvo en la cárcel. Entonces no pudimos comunicarnos.
Based on that, Judge, we just need a short adjournment.
Con base en eso, estamos pidiendo una postergación, señoría.
Probable cause conference will be adjourned to April 25th, 2024, 9 a.m.
Causa probable, la audiencia para causa probable queda postergada para el 25 de abril del 2024 a las 9:25 de la mañana.
Okay.
On continued. Thank you.
Gracias.
We have one more, Madam Interpreter.
Yes, sir.
Court does call the case of the people of the state of Michigan versus Luis Vasquez Leal.
La corte llama el caso del estado de Michigan contra el señor Luis Vázquez Villan.
Good morning, Your Honor. Marie Penn, Assistant Prosecuting Attorney on behalf of the people.
Would you mind repeating your name?
Marie Tana.
A nombre de el pueblo Maritana.
Attorney Feaster, Assistant Public Defender, on behalf of Mr. Vasquez Lil.
Abogado Pfister, auxiliar, a nombre del señor Vázquez Liu.
Mr. Vasquez Lil, please state your name.
Señor Vázquez, por favor, diga su nombre, Vázquez Liu.
Luis Alberto Vázquez Leal.
Thank you, Judge. I've had a chance to meet with Mr. Vasquez Lil and the people on this matter.
Gracias, señoría. Pude reunirme con el señor Vázquez Leal y el pueblo con respecto a este asunto.
Provided your court with a correct address for Mr. Lil. The one in the court file was previously incorrect.
En cuanto a la dirección del acusado, la dirección ingresada estaba incorrecta.
In speaking to the people and Mr. Vasquez Lil, we have not reached a resolution yet.
Hablando con la fiscalía y el señor Vázquez Leal, no hemos podido resolverlo todavía.
We would ask for a brief adjournment on this matter.
Estamos pidiendo una breve postergación en este asunto.
No objection.
Did you get that, Madam Interpreter? No objection from the people.
No hay objeción de parte de la fiscalía.
Probable cause conference will be adjourned to April 25th, 2024, 9 a.m. Bond continued.
Judge, if I can ask one
Uh,
question.
Let her go
Yeah.
ahead. Go ahead, Madam Interpreter.
Thank you, sir. La audiencia para causa probable queda postergada para el 25 de abril del 2024 a las 9 de la mañana. La fianza continúa.
Judge, if I could ask one question,
Señoría, tengo una
That-
pregunta.
that being, Mr. Vasquez Lil apparently lives in Indiana.
El asunto es que el señor Vázquez Leal aparentemente vive en Indiana.
May I submit a request for permission for him to appear by Zoom on the 25th? Or would the court consider that?
Estamos solicitando una autorización para que el señor Vázquez Leal pueda aparecer o comparecer para la audiencia por medio de Zoom, a menos que se considere indispensable que sea presencial.
Your Honor, I guess my first question would be, was he allowed to travel to Indiana? Live there?
What
That's
was-
my understanding.
Go ahead, Madam Interpreter.
I couldn't hear the question. I'm so sorry.
Was he permitted by the court to reside in Indiana?
La corte le autorizó vivir en Indiana, sería mi pregunta. I did not hear the response. I apologize.
I don't see any indication that the defendant could leave the state of Michigan.
No veo ninguna indicación de que el acusado pudiera salir del estado de Michigan.
Your Honor, the reason I have that concern is because our notes indicate that at arraignment, specifically we cited a flight risk because there were no Michigan ties. The criminal history is based in Illinois, and the defendant confirmed on the record that he gets mail in Indiana.
Precisamente hacía la pregunta porque en la lectura de cargos se indica el riesgo de escape o de que se perdiera de la vista el acusado debido al historial delictivo, debido a la falta de lazos con la comunidad y al historial delictivo en otro estado, en Illinois. Entonces se indicó que no debía salir de Michigan.
And furthermore, there were discussions with Magistrate Fink regarding this. Magistrate Fink had some concerns that his immigration status was further concerned for flight risk.
También, además, hubo una discusión con respecto a la condición migratoria que aumentaba el riesgo de escape.
And specifically, he was ordered not to leave the state without permission of the court.
Específicamente se le ordenó no salir del estado sin el permiso de la corte.
Judge, I am not at this time saying he has left the state. What I'm saying is that he normally resides in Indiana, and he is requesting permission to go to Indiana, where he normally resides. He has shown me let me stop so she can translate that.
Bueno, yo no he dicho en ningún momento que él haya salido del estado. Dije que él tiene domicilio y que tiene domicilio allá y está solicitando permiso para hacerlo por Zoom.
He has shown me a business card from his immigration attorney, who he is currently working with, and he is present here today, I think, showing that he's not running from this matter.
Él me mostró una tarjeta de su abogado de migración que está trabajando el caso y el hecho de que esté presente aquí es muestra de que está dispuesto a hacerle frente al caso y no está huyendo.
And again, Your Honor, when this was brought up with Magistrate Fink, the request did include information. Defendant, through his counsel, stated that he's an Indiana resident and that he would make the 3.5-hour drive to appear at all court dates. But even with that information, she denied his request.
En las actas consta que el acusado indicó que vivía en Indiana y que tenía que hacer un viaje de 3 horas y media para ir y venir, y aún así no se le permitió.
So as I was saying, Judge, I would be requesting that the court allow him to go to Indiana. If not, then he'll continue to make it work how he has been during the last several weeks.
Bueno, yo estoy solicitando que se le dé la autorización, pero si la corte no lo decide así, él continuaría haciéndolo como lo ha hecho en las últimas semanas.
And Your Honor, for the record, we would object based on what was stated. We do have concerns that he is a flight risk.
Señoría, nosotros sí tenemos objeción con base en lo indicado y consideramos que sí hay riesgo de escape.
Where is the defendant staying now while in the state of Michigan?
¿Dónde se queda mientras está en el estado de Michigan el acusado?
Understand the question? I'm gonna get my handy dandy app out, Judge. My understanding is, Judge, that he is house jumping while he's with his friends, because he does not have a permanent residence here in Michigan. His permanent address is in Indiana.
Su residencia permanente está en Indiana. Entiendo que él se queda en casas de diferentes amigos, puesto que no tiene una residencia permanente en Michigan.
If the court is concerned about where he is located, I'd ask the court to consider a tether, and you can see that he's here in the state of Michigan and has not left the state.
Le pido a la corte que considere el hecho de que él está aquí y no ha salido del estado.
I need an address where he's going to be staying while in the state of Michigan.
Necesito una dirección del lugar donde él se queda mientras está en Michigan.
While we're waiting, and just for the record, there was an interpreter present at the arraignment, so everything was interpreted.
Thank you.
Señoría, mientras esperamos, hubo un intérprete en la lectura de cargos y todo se le interpretó.
He indicates that his significant other or wife is present. He says that she can get the address of where they're staying at. If you want to hold him while past this,
Oh, I will be holding him.
I can get the address, Judge.
So go ahead, Madam Interpreter.
I couldn't hear it. It started, the audio started right in the middle. I apologize, sir.
Go ahead, Mr. Fisher.
Judge, I spoke to my client. He said that his wife has the address of the place they've been staying at here in Michigan. If the court is inclined to pass this, I can get that address from his wife.
Hablé con el cliente y dice que la esposa tiene la dirección del lugar donde se han estado quedando. Entonces, si la corte lo autoriza, podemos conseguir la dirección posteriormente.
I'm sorry, before we pass that, he was also supposed to get a sober link if he posted bond, and I'm not sure if that happened.
Would you mind repeating what you said? I'm so sorry. It's really
The
hard to
defendant
hear.
was also supposed to get a sober link prior to his release or after his release. Did that happen?
Se suponía que el acusado obtuviera un silver link
Can you
después de eso. Eso
check with
ocurrió.
if he's on the sober link?
He says he has one, Judge.
Okay.
Él dijo que tiene uno.
The defendant will be remanded to the custody of the sheriff pending verification of an address in Michigan.
Se va a ordenar la permanencia del acusado bajo custodia del alguacil hasta que se aclare el asunto de la dirección en Michigan.
Once that address is verified, defendant will be released on the previous bond that he has posted, but only after placement on a GPS tether.
Una vez que se haya verificado la dirección, el acusado quedará en libertad bajo la fianza que ya se había establecido después de que se le coloque un GPS.
So no need to recall it. Just provide your honor with an address. Okay. Thank you, Judge.
Calls the case of the people versus Chelsea Miller.
Alex Warren, Green on behalf of Ms. Miller.
Ms. Miller?
Can you hear me?
Yes, we can hear you. Do you have a camera?
Yep, I'm trying to turn it on. Here we go.
Okay, state
work?
your name, please. Yes,
Chelsea
we can
Miller.
see you. Can your name again?
Chelsea Miller.
To the plea we're doing?
That's right, Your Honor.
Court has before it a plea form that indicates that the defendant will be pleading guilty to added count 3 and 4. Count 3 being use of a controlled substance, that being fentanyl, 1-year offense, and count 4 being operating while visibly impaired, the 93-day offense. Upon her successful plea to those charges, counts 1 and 2 would be dismissed. There is an agreement that it's okay to seek 7411 on the added count 3, although I cannot bind the court to do that, but that's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
Hughes wasn't even stepping in. She just looked. Yeah. She just looked at him like, say something. All right. Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Chelsea Miller.
All right, you can put your hand down. And it is this court's understanding that you're going to plead to 2 misdemeanor charges. The first charge is that of the use of a controlled substance, that being fentanyl. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. You understand that?
Yes.
It's also this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 district. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
And you understand because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You
Yes.
understand you're giving up those rights, ma'am?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of these offenses?
Yes.
September 3rd, 2023, location of I-94 near Zebra Road, Scioto Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
What had you ingested?
I had marijuana and Flexerol. I believe they were oxys, fentanyl.
Pardon?
I believe they were oxys, but I found out that later that they were fentanyl.
Okay. All right. Were you stopped by the police?
Yes.
Okay. Why'd they stop you?
I guess somebody had called and said that I was driving erratically.
All right. You're not challenging the right of the police to stop you in this instance, are you?
No.
All right. Were you ultimately arrested?
Yes.
And were you taken to the hospital for a blood draw?
Yes.
And did a combination of controlled substances appear on that blood draw, including marijuana,
Yes.
as well as the fentanyl?
Yes.
Do you have any reason to dispute those test results?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your ingestion of controlled substances?
Yes.
All right. I'm having a problem only, ma'am. When you took what you thought was Oxycontin, you believe that that's what it was. Is that correct?
Yes.
Okay, so you did not know that you were ingesting fentanyl?
No.
She was not prescribed Oxycontin, Your Honor.
Right, so you want to do it to the Oxycontin. Okay, so you at least knew or thought what you were taking or intentionally thought that you would be taking Oxycontin.
Yes.
All right. It turned out to be something else, but you thought you were going to take a controlled substance that you were not prescribed. Is that correct?
Yes.
All right, I think that will do it. Counsel, have I complied with the court rule? Would it be proper to take this defendant's plea to counts 3 and 4?
And the defense is satisfied.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be May 6, 2024, 9 a.m. 9 a.m. before Judge Freshour.
Okay, thank you, Your Honor.
Bond with its conditions will continue. Thank you, ma'am. Court calls the case. People versus, is it Ruhala Hatame? Probably messed that completely up, but I tried.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Hamte.
I have before me a plea form that indicates the defendant would be pleading no contest to the charge of indecent exposure to 1-year offense. Upon a successful plea to that charge, the aggravated indecent exposure would be dismissed. That's the court's full understanding of the agreement.
Ours as well, Your Honor.
Raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name for the record.
Rohola, I'm Thai.
All right. Sir, it is this court's understanding that you are going to be pleading guilty or pleading no contest to the charge of indecent exposure. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it. I need to make sure that you understand it. First of all, means that you're not desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
All right. Still wish to, and basis for the no contest plea.
Civil liability, Your Honor.
To the charge, how do you plead, sir?
No contest, Your Honor.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today?
Yes, Your Honor.
Any question about those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on their form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and is reviewing Washington County Sheriff's Office report for their case number 23-40842. Any objection to the court reviewing that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
May 6th at 9 a.m. before Judge Freshour.
May 6, 2024, 9 a.m. before Judge Freshour. Bond in this matter with its conditions will continue.
Slight request, Your Honor, about bond.
Really?
I know.
Somebody's gonna do that and they're gonna go. Go
Two
ahead.
sentences, Your Honor. Mr. Hebtai is hoping to travel on Monday to Ohio and or Indiana to see the eclipse. It's something he's looked forward to for a very long time,
Ohio or Indiana?
depending on weather conditions. Preferably
Because
Indiana.
you can't see it here.
You can see it here, Your Honor, but it won't be in totality. So all it takes is to travel to Toledo. And I highly recommend, Your Honor.
Yeah. No, for us Michiganders, that's disputed territory. We don't go there on purpose.
Please, Judge.
Please. Fine. But you don't know whether you'll be in Ohio or Indiana.
Most likely Ohio, but if the weather is not cooperating, Indiana.
That's definite. Defendant may travel to Ohio or Indiana for eclipse.
Thank you, Your Honor.
Court calls the case People versus Rebecca Usselman.
Andrew Danis, Assistant Public Defender, with on behalf.
Your name?
Assuming Rebecca.
You made it all the way from Royal Oak, but the other one couldn't make it from Ann Arbor. Go ahead.
Your Honor, we have resolved this today. The offer. I saw it on your face. Your Honor.
Yeah.
Police report.
My face told everything. When we do this, if we could, Dennis, get it to my staff as soon as possible.
Yes.
I would appreciate it, because then I have a chance to review it more closely, but we'll make it work. All right. I have before me a plea form that indicates that the defendant will be pleading no contest to an added count 3 of attempted resisting and obstructing the 1-year offense. That upon a successful no contest plea to that charge, counts 1 and 2 would be dismissed. Agreement of no delayed or deferred. That's the court's full understanding of the agreement.
That is correct.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Rebecca Usselman.
All right. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Okay, 2 things I have to make sure you understand about a no contest plea. The first being that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
I also do have to advise you that I would not, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Understood.
Basis for the no contest plea?
Potential civil liability.
Ma'am, to that charge, how do you plead?
Say it again.
How do you plead to the charge of attempted resisting and obstructing?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Understood.
You understand you're giving up your right to appeal of right.
Understood.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and is reviewing Ann Arbor Police Department report for their case number 245900. Any objection to the court reviewing that report? Reviewing that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2 or count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and is ordered at 15th District Court probation. Sentencing in this matter will be
Before Judge Valvo.
April 17th.
Yes.
April 17th, 2024. What time?
30.
2, of course. Why? 2:30 before Judge Valvo. Bond will continue. Thank you. You can have that back. Court calls the case people versus LaSheria Williams.
Good afternoon,
Okay.
Your Honor. Deborah Geraldine Bledsoe Ford on behalf of LaSheria Williams.
Good afternoon.
It's very hard to hear.
Is it? Then you need to turn up your volume. I'm hearing just fine.
Okay, I did.
Okay. Can you hear me?
Yeah, enough, just enough. So I'll speak quickly. My client is on Zoom also. She's ill. I believe she has the symptoms of COVID. But I'd like to plead her not guilty, please, and request a probable cause hearing. I mean, a PCC.
Okay, well, we're on the PCC now, so you need an adjournment?
No, I misspoke. There she is. I see her. No, we'd like
Yeah,
a probable
she's on.
cause. Hi. We'd like a preliminary exam. I know this case. It was dismissed previously, and then it was brought as a domestic violence and home invasion, family members, and then it was non-appearance. It was dismissed. Now it's been reissued.
Okay. So let's do this. I'm assuming all discovery is complete and the witnesses will be available certainly after the 16th, but because if she has COVID, let's do it this way. I'll set it for April 23rd.
Thank you.
Well,
In the morning?
hang on. Preliminary examination in person, April 23rd, 2024, 9 a.m. before Judge Washington.
Thank
Okay?
you.
Bond continued. Thank
Yes,
you.
thank you very much.
Court calls case, people versus Iad. You said Ambulas?
Good morning, Your Honor. Joy Dean, Senior Assistant Public Defender with
Good
an,
morning, Your Honor.
would you please state your name, sir?
Iyad Aboulish.
Your Honor, we are requesting a short adjournment. We did ask for some additional discovery and we're in ongoing negotiations.
Probable cause conference without objection, April 25th, 2024, 9 a.m. Bond continued.
Thank you.
Case, people versus Mario Atkins.
Your Honor, we're going to bring on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Atkins. Mr. Atkins, would you please state your name for the record?
Mario Atkins. Thank you.
Your Honor, Mr. Atkins is indicating that he's in the process of retaining counsel. We're asking for a 2 to 3 week adjournment for him to be able to do that.
How long?
2 to 3 weeks.
You think you can do that within that time, sir? Yes, sir. This will be your only adjournment for that purpose. Probable cause conference, April 25th, 2024, 9 a.m. Bond continued. Calls case of the people versus Mary Barney.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender with and on behalf of Ms. Barney. Your Honor, there has been an offer made for Ms. Barney to plead to an added count of 2, I believe, of child abuse 4th degree. At this time, we're in agreement with the prosecutor for that offer to remain open. We wanted to just check in with her attorney and her child welfare matter. So we're asking for a short adjournment. I did.
Are you
reach out-
aware of the conditional bond violation?
Yes, Your Honor. I did reach out to Ms. Willenbring and asked yesterday to ask her if I could have a copy of the report that goes with that And she indicated, well, I'll let her speak for herself.
We have Pro briefly, Your Honor.
You may. A report of a violation, it does not appear to the court at this time that there was a violation, for a lot of reasons, which I will not go into the specifics on the record, but I'm satisfied that it may not be. All right.
Thank you, Your Honor. We are asking for a short adjournment. There's been an offer and we want to be able to confer with her child welfare defense attorney and
Got it. Probable cause conference, I'll give you the 25th, so you have time to work through all of that. April 25th, 2024, 9 a.m. Bond continued. Court calls the case, People versus Ezra Fleury.
Ron Brown appearing on behalf of Ezra.
Talked to him yesterday.
How'd that go?
I thought he was gonna show up.
We all did. Ezra Fleury, no response. Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately. Thank you. Court calls the case of the People versus Devin Gissendaner. Danner.
Then Public Defender Queen Anderson, on behalf of Mr. Gissendaner, please state your name, sir.
Devin Gissendaner.
Oh, okay.
She did.
I'm
She's
sorry.
quiet. She's quiet, unlike some. Go ahead.
Your Honor, I had a chance to speak with Mr. Gissendaner. There is a misdemeanor offer. He's also HIDA eligible. We've discussed both. He wishes to set this case for preliminary exam.
Discovery is complete.
It is, Your Honor.
People have their witnesses available on the 16th. Preliminary examination will be set in person, April 16th, 2024, 9 a.m. before Judge Fresh Hour. Bond continued.
Thank you, Your Honor.
Thank you.